number 9, my lord. Of
Item
hearing
number?
list. 9 of hearing list, my lord.
9 of the hearing list.
As the learned APP is having hearing on the principal bench, my lord, if the matter be fixed for Tuesday next week.
Just a minute.
Yes.
This is hearing list from 17 to 21, yes. Item number 9.
Yes, my lord.
That was kept for today, I think.
Yes, my lord.
So, you want to do
But
it today?
the learned APP is having fixed hearing matter on the principal bench, my lord.
Okay. Okay, it has been submitted by the council appearing for the learned PP that she is engaged in a matter in the principal seat and therefore the matter may be taken up in the next hearing list. Or you want it tomorrow?
Next Tuesday, my lord.
Next
if
week,
possible.
In the next hearing week, stop. List accordingly in the hearing list in the coming week.
25th, my lord. 25th, if possible, my lord.
20, no, we'll keep it on the hearing list, you make a mention.
Yes, my lord.
And another thing, when you appear in the court, we expect you to button up your coat so that
Yes, my lord.
the uniform is complete, right? Okay.
I'm obliged, my lord.
All right. Any other mentions? No.
Daily list for motion, item number 2.
Yes.
Please, Your Lordship.
Yes.
This criminal petition is for modification of the bail bond.
What is the condition imposed?
Plus, the bail order is at page 99 to 102. The operative part is at, my lord, page 101 under point number 5. Condition number 1, that is regarding the bail bond amount, my lord.
Where is it? What is the amount given?
3 lakhs, my lord.
What is the difficulty? You don't have to deposit the money now.
Yeah, my lord, it is.
It
they
is a
have
bond of
problem.
3 lakhs. Some person has to say that, okay, I'll pay 3 lakhs if you run away. He doesn't deposit
Well,
the
let's
money
see.
today.
He has a permanent address.
Haha.
He has a permanent address. He is from Churachandpur, Manipur.
No, so be it, because he's out of the state.
Yes.
The learned trial court has thought it fit that someone should stand up to say that if he runs away, I'll pay up the 3 lakhs. Is it not? So, what is difficulty in that?
Because since the bail order was passed on 22/8/2025, but due to these difficulties, my lords, the petitioner is unable to meet the bail condition. That is the problem. So the grounds of granting bail is that, my lords, due to violation of the fundamental rights, my lords.
The issue is this, if it had been, say, if it had been that you are required to pass, to deposit your Aadhaar card which you do not have, for whatever reasons, then we can modify it, that it is a document which is not in existence with you. But this amount of bail bond is something which is not required to be deposited. Is it required to be deposited?
Not my lords, but
No. You
the
have to give a bond that I'll pay the amount.
there are two sureties is required, and that the two sureties must show that's financial soundness.
That can be by way of your pay slip, that can be by way of property, whatever. You have to, because a local person, it was a different thing. But if you jump the bail condition, it will be a search in Manipur. That has to be compensated by the bailer.
By
Is
the
it
bail.
not? I don't think that condition would require. Anyway, we'll issue notice.
My lords.
As of today, we are not doing it. Yes. This petition under section 528 read with 483 1B of the BNSS has been preferred by the petitioner, praying for modification of the condition of bail which was imposed by the order dated 22/8/2025 by the Special Judge, NDPS Court, Aizawl District, Judicial District, Aizawl, Mizoram, full stop. The condition of which the modification is sought relates to the execution of a bail bond of rupees 3 lakhs with two sureties who shall also execute the same amount of bond. Full stop. The learned counsel for the petitioner has submitted that although he would be, although there is a probability that he would be able to fulfill the other conditions imposed, comma, the bail, the surety amount of rupees 3 lakhs is posing as an impediment on his being released on bail, full stop. Issue notice. Yes, we'll keep it next week. It's a bail matter.
Yes,
We've done
my
the
lord,
bail.
as per my senior instruction, if we may be allowed at least 2 weeks' time to get
See,
instruction.
the bail has already been granted,
Yes,
is
my
it
lord.
not? We just want to know that if the amount can be modified.
Okay, my lord.
Either you say that yes, if it is modified, the state would not have an objection, we can modify it immediately. But if you say that there are objections, we'll consider the objections.
Okay, my lord.
Otherwise, that he is entitled to bail is not a question now,
Yes, my lord.
is it not? So we'll fix it next week,
Yes, my lord.
sometime in
Okay.
Thursday. You just have the instructions whether the bail bond can be, the surety amount can be modified without the objection of the state.
Yes, my lord.
Okay. Mr. So-and-so, counsel appearing for the PPA, appears and accepts notice, full stop, extra copies during the course of the day. List again on 27th of November. Because the Supreme Court has said that the conditions must be such which can be met by the
Understand.
accused once the bail is granted. You can't give impossible conditions.
Much obliged, sir.
Item 3.
You also come up with what is the amount you could,
Yes, my lord.
What
This
is
is
the
also the
amount?
same,
Make a
similar matter,
suggestion.
my lord.
Huh?
Similar matter,
Similar.
yes.
Acha, you keep the others will remain the same. The date of the order will become 10/9/2025. And the bail amount and the surety amount is
5 lakhs.
5 lakhs.
okay. The rest will all remain all the same. Yes, you bring the judgment saying that the bail conditions
Yes.
can be modified
Yes, my lord.
for a person to meet it.
For
Highly,
admission,
highly obliged.
item 4.
Rajab, the government advocate was directed to get instructions.
Yes, Your Lordship. I'm seeking another 3 weeks' time to file my affidavit.
No, not the affidavit. I said the instruction. Why not? Why not the
Your
demarcation?
Lordship, the thing
Simple
is
as
that the counsel who handled this matter is on leave. She is on maternity leave.
Item 4.
It's item 4.
Kero yun.
Oh,
The matter was
Lute
handled
Kongolo.
by Caroline Lungoy Puye, and she is on maternity leave, Your Lordship.
just the last occasion, Lute ding alone.
Exactly,
Also that means,
Lute appeared on behalf of Caroline, since she is on maternity leave, Your Lordship.
No, we'll fix it again in the next week. Just find the instructions. When can you have the demarcation made?
And regarding that, I have to take instruction to
Only the
her.
demarcation part.
Yes, I will ask her, Your
Because
Lordship.
if the demarcation, if in the demarcation we see that his land has been included, then the matter will proceed. If his land is not included, once the demarcation is just vacate it.
I understand, Your Lordship. Now she is on lack, so if the matter may be passed over.
We'll keep it on the next week.
Yeah, she's come.
Ah, she's coming. Yes. Instructions, madam. There is no hurry. You can give it slowly.
Yes, Your Lordship. I have received instructions yesterday,
Ah.
and it does fall within the right of way. And if I may be allowed to submit all my instructions in the form of affidavit, Your Lordship. So if two
You
weeks time
file
will be
the-
granted.
Then we do this. You do it this way. You file the affidavit by 28th of November,
Yes, Your Lordship.
and on the we'll have it on the first week of December, so that we can decide whether the demarcation has to be done immediately or not.
Yes, Your Lordship.
Because the demarcation being done, the problem is solved.
But Your Lordship, at this stage, already the concerned area is covered by the present railway station. So even if it would be impossible to do the demarcation at this stage, Your Lordship.
So that means it has, his land without being acquired has been used.
Yes, Your Lordship.
That will be very difficult then. Okay. Mr. A.R. Malhotra, we'll fix it, we'll allow them to file the affidavit.
Affidavit. Let them file the
On the
affidavit.
first week of December, we can come to a conclusion.
Yes, Your Lordship.
Heard Mr. A.R. Malhotra, learned counsel appearing for the petitioner. Also heard Ms. Lanlun Hui. That's how
Yes,
you
Your
pronounce
Lordship.
it? Okay.
Yes, Your Lordship.
Learned government advocate appearing for the respondent number 2 and 4.
Lordship, I'm appearing on behalf of respondent number 1 and 5.
So and so appearing for respondent number 1 and 5. Huh? By the last order, the learned government advocate was required to have her instructions as to whether a demarcation process can be carried out on the land in issue, full stop. Today, the learned government advocate has submitted that she has received her instructions, and it appears from the instructions that the land in issue might already have been occupied in construction of the railway
Yes, Your
station,
Lordship.
of the
Yes, Your
railway
Lordship.
station. Full stop. The learned counsel for the learned government advocate is allowed 1 week time to file her affidavit. The petitioners would be at liberty to file their reply, if any, to the said affidavit. Full stop. List the matter again on the 4th of December.
Your Lordship, if it can come up on 3rd.
3rd of December. 3rd would be a DB day.
Oh, sorry.
Wednesday.
So you take second would be too early for you to reply.
Your Lordship, may I make 8th then, because
8th.
3rd we have a principal seat matter.
Okay, on the,
Sorry, 4th, yeah.
on the 8th
8th.
of December for further consideration.
For orders, item 5.
May I please, Your Lordship?
Yes.
My Lord, I just have received a death certificate of the respondent. It seems that notice has been received by his representative, his wife, and they have sent a death certificate of the respondent.
Oh, so
So
you'll
if
have
I may
to
be
know.
allowed to make a substitution.
The learned counsel appearing for the applicant has submitted that although the postal consignment had been delivered at the address, the respondent has expired, and where is the postal consignment track? Yes. Although the postal consignment had been delivered, the respondent has expired in the meantime, full stop. The learned counsel for the applicant therefore prays for an opportunity to file appropriate application to bring on record the fact of the demise of the respondent and to implead his legal errors if so required, full stop. Accordingly, list the matter along with the IA proposed to be filed.
Deeply obliged.
You are not fixing a date, you file your IA, it will come up together. Okay.
For delivery of order, item number 1.
Yes. Take down. This matter was heard at length on 17/11/2025 and directed to be listed today for delivery of orders. Full stop. Next para. Heard Mr. So-and-so, learned counsel appearing for the petitioner. Also heard Ms. So-and-so, learned counsel appearing for the respondents. Full stop. This writ petition has been instituted by the petitioner praying for squashing and setting aside the impugned order dated 12/12/2023 passed by the respondent. You can take your seats. Respondent number 2. And also for quashing and setting aside the suspension order dated 22/5/2024. Huh?
Your Lordships, if I may just clarify that point, that suspension, my lords, we are forfeiting our challenge to that.
No, no. What is this impugned order of 12/12/03? Where is it? What is the connection? After your 12/12/2023. Some typographical error. Impugned order in the
My lords, we had additionally challenged the suspension order.
no. What is 19/12/2023? I'm told there is some confusion that it's for delivery of orders, so I would be delivering the order today.
Yes, sir. Yes,
So I clarified with the court master, when we say pronouncement of judgment,
yes.
it is I have the judgment, I'll pronounce it in court.
Yes.
But when we say delivery of orders, we deliver the order in the court.
My lords.
All right? You are challenging the order dated
My lords,
1912.
1912.
The prayer clause is wrong. Yes, what did I say? Challenging the impugned order dated?
Typo.
No, 19/12/2023. 223. Passed by the Principal Secretary to the Government of Mizoram, Health and Family Welfare Department, whereby the punishment of, you will take it in the inverted commas, reduction to a lower stage in the time scale of pay by 2 stages for a period of 3 years with effect from the date of penalty, with further direction that the government servant shall earn increments of pay during the period of reduction, full stop, on expiry of the period of penalty, comma, the reduction will not have the effect of postponing future increments of pay under Rule 11(5) of the CCS within bracket CCA Rules 1965. Full stop. Okay? Next para. The petitioner was serving, and the petitioner is serving as a medical officer and has rendered 7 years of service approximately in the Department of Health and Family Welfare, Government of Mizoram, full stop. While the petitioner was posted as medical officer at the Public Health Center, Sialsuk, Mizoram, within brackets hereinafter referred to as the Health Center, bracket close, she was placed under suspension by an order dated 2/6/2022 passed under Rule 10, Sub-Rule 1 of the Central Civil Service, within bracket CC, Classification, Control and Appeal, bracket close, Rules 1965, within bracket, hereinafter the Rules of 1965, bracket close. In contemplation of a disciplinary case, disciplinary proceeding Full stop. The memorandum of charge dated 12/7/2022 was served upon the petitioner containing 3 articles of charges which are quoted below for a ready reference. You'll take it from page 6, para 7. Huh? Full stop. By separate orders dated 1/8/2022, the enquiry officer and the presiding officer were appointed by the disciplinary authority. Full stop. The written statement by the petitioner was filed through her defense assistant on 25/8/2022, comma, the written statement by the presenting officer was filed on 6/9/2022 and a counter statement by the defense assistant of the petitioner was filed on 6/9/2022. Full stop. The order of suspension dated 2/6/2022 was revoked by the order dated 26/9/2022, comma, contemplating that the manner in which the period of suspension would be treated shall be finalized upon finalization of the disciplinary proceeding. Full stop. An enquiry report dated 26/9/2022 was served upon the petitioner, comma, which reflected that the Article 1 and Article 3 of the Memorandum of Charge were in the opinion of the enquiry officer, comma, proved, and Article 2 stood not proved. Full stop. The petitioner filed her reply to the enquiry report on 4/11/2022. Full stop. A response to the same was served upon the petitioner on 22/11/2022. Where I have said that response was served, that response by the Principal Secretary to the Health and Family Welfare Department was served upon the petitioner on 22/11/2022, है ना? What, were you ever given that finding of guilt?
My lords.
Before this 22/5, if you have page 11, para 15,
Yes.
there you say that they had sought for a representation
Yes.
on the proposed penalty.
Yes, my lord.
But were you given anything that they were finding you guilty, that the guilt was proved?
No,
They did
my
not give
lords,
any
it's-
such order.
After the IO's report, it was only the disciplinary authorities' concurrence.
Where is that?
And of 273, the IO, the final order.
No. Prior to that, where is 22/5/2023? There's an order of 22/5.
23.
That is page 263. Okay.
That was the Commission's recommendations of the punishment. Public Service Commission.
So So were you ever told that you were being held guilty? Prior to that? No.
No, my lords.
No, no. Do we have the CCS rules? CCS, CCA rules. 15.3 they say, okay. Were you given a copy of the advice of the commission?
I'm sorry, madam.
Were you given a copy of the advice of the commission?
Yes, yes, my lords. 263 as your lordship saw. Two 264 is the advice. Translated at 260.
What kind of what we understood of the CCS CCA rule is they will send the entire file to the commission.
Yes.
The commission will have a tentative decision on the guilt or otherwise,
My lords.
and then they would say that yes, this is the proposed penalty.
My lords.
Here we find that already the guilt has been taken up,
Yes.
and only for the punishment, only for the penalty, it has been referred.
Yes.
Is it correct? For its advice. Copy of the report of the inquiry towards tentative reasons for disagreement. Comments of disciplinary authority on the representation of the government servant on the inquiry report. And disagreement note, if any. Disciplinary authority shall forward or cause to be forwarded a copy of the advice of the commission received under clause A to the government servant, who shall be required if he so desires. Do you have a copy of the
CCS.
CCS?
My lords,
You are not prepared today, I know, because wrong impression. Okay. It says here
yes, my lords.
that the disciplinary authority shall forward or cause to be forwarded a copy of the advice of the commission. And at, you have it, page 154.
Yes, my lords.
After 3,
Yes.
at serial number 4,
Yes, my lords.
the disciplinary authority shall consider the representation, if any, submitted by the government servant, and record its findings before proceeding further in the matter. That means,
My lords. Yes, yes, my lords.
thereafter, if the disciplinary authority having regard to the findings is of the opinion that any of the penalty is to be imposed,
Should be.
then it shall impose the penalty. But here,
Yes, this
apparently,
finding
it
of
has
guilt is
given the
not-
finding, they've sent the finding,
Yes.
they only took an advice on the penalty.
Yes.
Is it not? And if you look at 6,
Yes.
last line, it shall not be necessary to give the government servant any opportunity of making representation on the penalty.
Yes.
They are giving you an opportunity of making the representation.
That opportunity I received, but that 4 was.
But not prior to,
Yes.
that is done, okay. So now, you take down. The matter was then referred to the commission. To the state has not filed the affidavit, na?
My lords, they have.
You have filed your
Yes,
affidavit?
sir, Lord Chief.
Okay. The matter was then referred to the Mizoram Public Service Commission, who by the order dated, who by the communication dated 16th of May 2023 accepted the proposed major penalty sought to be imposed upon the petitioner, full stop. By a communication dated 22/5/2023, comma, the petitioner was required to submit a representation on the proposed penalty advised by the Mizoram Public Service Commission, full stop. The petitioner then preferred her representation on 24/8/2023. It took such a long time. 24/8/2023. Full stop. By an order dated 19/12/2023, comma, the penalty as mentioned in the foregoing paragraphs was imposed upon the petitioner. Subsequently, by another order dated 22/5/2024, comma, the period of suspension spent by the petitioner has been directed to be treated as on duty for all purposes except payment of actual pay and allowances. Full stop. This led the petitioner to approach this court by the present writ petition. Full stop. Next para. Mr. So-and-so learned counsel appearing for the petitioner has submitted that. Yes, recapitulate your submissions.
Yes.
What did you make? Do you remember?
My lords, one is, my lords, the charges and the findings which have been concluded by the IO, they are beyond the articles of charge.
We'll go one by one. You also go through the file till then. The learned counsel for the petitioner has submitted that a bare perusal of the articles of charge framed against the petitioner and the findings in the enquiry report and the conclusion arrived at by the disciplinary proceeding would go to show that the charges found proved do not tally with the articles of charge informed to the petitioner.
My lords, can I go article wise? Should I?
Yes.
My lords, insofar as Article 1, the charge was, if your lordships has the inquiry report, the discussion starting at page 225. Yes, this is the discussion, my lords. In the memorandum of charge at the bottom, my lords, article of charge 1. The CEO is alleged to have been discharging Sri Lal Rengpuya on the night of 12 May 22 in connection with accusing of stealing money without issuing proper discharge certificate from Sialsu. So, my lords, the charge is basically not issuing a discharge certificate. The findings are at 233, the concluding. They have found me guilty of not acting smoothly, my lords. Page 233, my lords. On analysis of the facts and circumstances mentioned above, it may be mentioned here that it is very unfortunate for both on the part of the CEO and the said Pulal Rengpuya that the former did not issue formal discharge certificate in favor of the latter. At the same time, the illness of the latter escalated and died later, which caused great annoyance, gossip in the public, thereby suspecting the CEO that she expelled the latter from the PHC, thereby causing death consequently. Has such missing of money not happened, things may become different, and it may be assumed that the said Pulal Rengpuya might have been discharged from the PHC properly by the CEO as were done earlier. Therefore, it could be seen that everything could not be dealt with smoothly by both the CEO, charged officer, and the said Lal Rengpuya late on account of the said missing of money. Even though the charged officer produced the relevant documents which indicated that the discharge certificate of Pulal Rengpuya was prepared lately on the night.
Yes. The learned counsel for the petitioner has submitted that while the allegation against the petitioner was that she had discharged a patient without issuing proper discharge certificate, comma, the conclusion arrived at by the enquiry officer, comma, which was agreed to by the disciplinary authority, reflects that it was not ascertained as to whether the person or the patient had left the hospital willfully or otherwise. The learned counsel for the petitioner submits that it has been ascertained in the enquiry itself that a discharge certificate had been prepared by the petitioner but was not issued, and at a later stage it was also ascertained that the patient, it was also stated that it could not be ascertained whether the patient had left willfully or was actually discharged. Full stop. In such circumstances, comma, the learned counsel for the petitioner submits that the finding that the patient was discharged without proper discharge certificate could not have been held to be proved against the petitioner. Full stop. The article of charge 2 having been found to be not proved, comma, no arguments are required in the said against the said article. Full stop. With regard to the article of charge 3, the learned counsel for the petitioner has submitted that the said charge related to an allegation that the petitioner was involved in selling medicines at the hospital canteen by using drug licenses issued to other staff. Was it issued to others? No. As per staff nurse, she had lent her drug license. How can a staff nurse have a drug license?
No, my lords. She had made a contradictory statement. Her father had.
Okay, no, the allegation is that the nurse had given her.
No, my lords. That allegation is also not there. Actually, the allegation is that you sold medicines at the PHC.
Please see the
Yes.
page number 43.
43. Yes, my lords. Had lent. I'm sorry. Yes,
That
yes, my
while
lords.
functioning as medical officer, Linda so-and-so was selling medicines. As per report of PI so-and staff nurse, she had lent her drug license.
Yes.
So the allegation is that she was using the drug license.
Yes.
The petitioner is Linda,
Yes.
is it?
Petitioner is Linda, my lords.
So
Your lordships is right.
what did they say? To other staff, namely P. Lalchawi Maui, a staff nurse of the health center. Full stop. You'll find it at page 43.
Yes.
You'll find the name at page 43. I'm marking this with, I'm highlighting it, It'll be easier. Okay. The further allegation was that the petitioner was selling drugs without valid drug license, which was in violation of government standing law, rules, regulation, and established procedures in the CCS conduct rules, and also in violation of section 18 within bracket C of Drugs and Cosmetics Act 1940. Full stop. The Learner Council submits that where is that 236?
36.
Where is the evaluation?
And the inquiry 237.
The Learned Counsel for the petitioner submits that while evaluating the said charge, the inquiry officer has referred not only to the circular issued by the Joint Director and the letter addressed to the Undersecretary to the Government of Mizoram, the inquiry officer also relied upon an inquiry report of the Joint Director within bracket Food and Drugs bracket close, Controlling and Licensing Authority, Director of Health Services, submitted to the Principal Director, Health and Family Welfare Department, Government of Mizoram. Full stop. The Learned Counsel for the petitioner has submitted that the said report of the Joint Director was not a part of the list of documents supplied to the petitioner along with the memorandum of charges, and even during the inquiry proceedings, no attempt had been made on behalf of the disciplinary authority to prove the authenticity of such a report, full stop. The learned counsel for the petitioner has submitted that the said report, although produced, was it produced during
No,
the
no, my
inquiry?
lords, it was
Huh?
not.
But they are saying that S 75 to 78, where is it?
My lords, the production, my lords, apparently, my lords, this is the statement of the other side that they have made in these proceedings, that it was not produced. We've not been provided. That is there.
Huh? So the learned counsel for the petitioner has submitted that the aforesaid report had not been provided to the petitioner during the inquiry proceedings, and as such, the inquiry officer and another inquiry officer had acted to the prejudice of the petitioner when such a report was allowed to be a part of the inquiry, and the disciplinary authority thereafter committed grave error when it took into consideration the finding of the inquiry officer to come to a conclusion that the Article 3 of the Memorandum of Charge also stood proved. The learned counsel for the petitioner has further submitted that although the article of charge number 3 had specifically asserted that the petitioner was using the drug license of a staff nurse, during the inquiry, it appeared that the said staff nurse did not have any drug license issued in her favor. Full stop. It is the submission of the learned counsel for the petitioner that the absence of the drug license in the name of the staff nurse ought to have in itself been enough for the inquiry officer and the disciplinary authority to come to a conclusion that the article of charge at serial number 3 stood not proved. He said that instead of taking such a recourse, the inquiry officer proceeded to find out whether the petitioner had been involved as a mediator in sale of drugs, in sale of medicines inside the PHC, a charge which was neither framed nor informed the petitioner that it would be inquired into. Full stop. Anything more? Those witnesses were not,
Yes, my
they
lords.
did not appear in the inquiry, some of the
My lords, the
witnesses.
inquiry report which was referred to, that was also not proved. The joint director, that inquiry report, my lords, he was not examined.
That I have
Yes.
said.
And my lords, at page 191, insofar as the drug license, the statement of Lalsoi Moi, she herself says that this is my This is not my drug license, it's my father's. At page 191 bottom. Examination in chief by presenting officer.
The learned counsel for the petitioner further submits that even going by the statement of the staff nurse, comma, whose license was alleged to have been used, comma, had submitted that the petitioner had used her father's drug license and father's drug license, full stop. The learned counsel has submitted that the staff nurse, comma, who had appeared as a witness in the inquiry proceedings, had contradicted herself at different times during the proceeding itself, and therefore her statements could not have been taken to be reliable to come to a finding of guilt against the petitioner, full stop. This
Yes.
members of the NGOs, did they give their statement before the inquiry officer?
They gave, my lords.
Huh?
They gave.
They gave, no?
SW, here was state witnesses 11, 12, 14. 11, 13, 14 and 15, my lords. Page 237.
11. He has further submitted that the members of the village council
My lords, Macy, members
had
of...
made statements only on hearsay basis. Huh?
No, my lords, your lordship just
What
put
is
it
hearsay?
correctly, my lords.
Hearsay basis, no?
Yes, yes.
I have heard, it is all I have
Yes.
heard. Hearsay basis, and therefore their statements ought not to have been relied upon to come to a finding of guilt of the petitioner. That's true. The learned council has placed reliance on the following judgments to buttress his arguments. You take down this list. This list is here. Take down everything. Ms. So-and-so learned counsel appearing for the respondents has opposed the submissions made by the learned counsel for the made on behalf of the petitioner, and has submitted that the provisions of the Drugs and Cosmetic Act 1947 are very much applicable to the state of Mizoram, and therefore the very act of the petitioner in selling drugs within the health center premises on the basis of drug license which were not issued in her name is a misconduct under the CCS within bracket conduct rules. Full stop. She has submitted that each and every aspect of the inquiry proceedings had been duly considered by the disciplinary authority, and even before imposing the punishment, the petitioner had been given an opportunity to represent against the proposed penalty. Full stop. She has submitted that the petitioner had been supplied a copy of the inquiry report. The petitioner had been allowed to participate in the inquiry proceedings, which opportunity she availed by resorting to cross-examination of the witnesses produced on behalf of the disciplinary authority, the petitioner had been supplied a copy of the inquiry report, to which she had also filed a representation, and the petitioner had also been supplied with the proposed penalty, against which she had filed her representation. Full stop. In view of all the above, it is submitted by the learned counsel for the respondents, that it cannot be a case where the petitioner can plead that the principle of natural justice had not been adhered to, or that there had been any deficiency in the procedure during the inquiry that would lead to vitiate the inquiry at all. Full stop. Yes, madam, you have taken the ground of the appellate authority. Who is the appellate authority when the government gives an order?
Your Lordship, they would not have any appellate authority in this.
There is no appellate authority.
Yes, Your Lordship.
Yes. The learned counsel for the respondent has submitted that there is a provision in Rule 26 of the CCA rules 1965 to prefer an appeal and the petitioner had also availed that appeal, that opportunity of preferring the appeal, which was rejected by the department on the ground that since the governor had exercised the power as a disciplinary authority, no appeal would lie. Full stop. She has submitted that, therefore, the question of consideration of the appeal submitted by the Chief Secretary, question of consideration of the appeal submitted to the Chief Secretary cannot be entertained in the instant case. Full stop. Though the proceedings of the inquiry, though the inquiry proceedings have not been placed before this court, it is not though, right? Since the inquiry proceedings have not been placed before this court, the court has to proceed on the materials available on record. Full stop. On a perusal of the records annexed to the writ petition, comma, which are not disputed by the respondents, comma, it appears that there is substantial force in the submission of the learned counsel for the petitioner that the Article 1 of the Memorandum of Charges was different from the article, from the charge that the enquiry report had shown to be proved. Full stop. It also appears from the enquiry report and the memorandum of charge, as well as the order passed by the disciplinary authority, that there is no record to the effect that the copy of the enquiry report relied upon by the disciplinary authority and the enquiry officer enquiry report prepared by the Joint Director of Health Services, relied upon by the enquiry officer and the disciplinary authority to have been provided to the petitioner during the enquiry proceedings, or that the said enquiry report had been proved during the enquiry proceedings in the manner required in law, full stop. In the opinion of this court, comma, the alteration of charges against the petitioner. Now, the alteration of the charge which was made known to the petitioner, comma, but proved as a different charge as regards Article 1, and the non-supply of the report of the Joint Director of Health Services to the petitioner during the enquiry proceedings has caused prejudice to the petitioner in the enquiry proceedings, comma, which would have the potential to vitiate the enquiry, since the petitioner could not avail of an effective right of defense during the proceedings. Full stop. It is one thing to say that the evidence led by the it is one thing to say that the sufficiency or veracity of the evidence led by the disciplinary authority need not be gone into by this court while exercising powers under Article 226 of the Constitution of India. But it is another thing, but it is another matter that when evidence is led and charges are altered without notice to the petitioner, comma, this court is required to evaluate as to whether such evidence and such alteration of charge has been done, has caused prejudice to the charged officer, full stop. In the present case, this court finds that the alteration of the charge and the reliance on evidence not proved during the enquiry proceedings and taken on record without notice to the petitioner has caused prejudice to the petitioner. Full stop. In view of the above, this court has no hesitation to hold that the enquiry proceedings and the impugned order, the enquiry proceedings, which culminated in the enquiry report dated, what was the date?
1912.
No,
Inquiry
that is the penalty order. Enquiry report,
It is 26/9/2022.
26/9/2022. And the subsequent order dated 19/12/2022 cannot sustain the scrutiny of law and deserve the interference of this court, full stop. Accordingly, according the order dated 19/12/2022 stands interfered with, full stop. Since this writ petition has been disposed of by noting the procedural lapses during the enquiry proceedings, the same shall not act as a bar for the disciplinary authority to proceed in accordance with law with regard to the charges already framed, if it so desires, full stop. It is, however, made clear that any such process should be initiated and culminated within a period of 2 months from the date of receipt of a certified copy of this order, full stop. Since the penalty order has been set aside by this court, and in the event that the disciplinary authority does not proceed with the inquiry, does not conclude the inquiry, if any, within a period of 2 months, the impugned order dated, what was the next order of the suspension? That
22/5/24.
22/5/2024 shall also stand quashed, thereby regularizing the period of suspension of the petitioner for all purposes, full stop. In case the disciplinary authority conducts an inquiry, the fate of the period of suspension suffered by the petitioner shall be dependent on the outcome of the said inquiry. Stop. Writ petition disposed of, no order as to cost. Okay. Now this is what we have tentatively taken down. We'll add a few judgments, make a few corrections here and there.
Yes,
And you would have the order by Monday. Probably we'll have it on the board. So tomorrow I'll be traveling back.
yes, ma'am.
Saturday I have some judicial academy work.
Yes, ma'am.
Sunday nobody works. Monday you'll have the order.
Extremely grateful, madam.
Much obliged, Lordship.
Keep this there. Oh, beach mein aap likhiye. The learned counsel for the respondent has relied upon the judgment dated so and so to emphasize that in case if fault is found in the inquiry proceedings, the matter is required to be remanded back for consideration by the department.
Hearing list, item number 6.
Item number? What is that? Six. Why was it part heard sort of? Yes, why part heard?
May it please your Lordship.
Yes?
My Lord, on the earlier occasion, your Lordship has raised certain queries which I think I did not sufficiently answer on the previous occasion.
What was the query?
Firstly, your Lordship had asked me the question whether I'm only challenging the termination of the post or I'm also challenging the abolition of the post.
Yes.
I am challenging both, my lord, because they come from the same order. If we look through the said order again, on the subsequent paragraphs, it specifically states that these posts have been revoked in the same order itself. So, I just want to clarify that at the outset.
Where is that order?
The order, my lord,
The impugned order is at page
page number 249.
49. Yes.
Your lordship has got it? On the third paragraph, whereas the Executive Committee in its meeting held on 13 January 2021 had unavoidably resolved to nullify and revoke the said orders issued via memo number so-and-so. Now, therefore, in the interest of the general public and in pursuance of the resolution of the Executive Committee meeting dated so-and-so, the competent authority hereby revoked the said orders issued via memo number so-and-so with immediate effect. In consequence whereof the services of the appointees in respect of the above revoked post, as shown in Annexure B, are hereby terminated with immediate effect. So they have revoked the previous notification, which is the creation of the post, which is the notification of the creation of the post. So I just want to clarify that at the outset, my lord.
Okay. So the case here was that they had created some posts.
My lord,
You were appointed to the said posts.
correct.
Then there was a change in the members of the council.
Correct.
These people, they took a resolution that the earlier creation of post in your appointment is wrong, and therefore both are done away with and you lose your jobs.
Correct.
And that was done within a period of, I think, 9 or 4 months.
Correct.
Something like 4 months, is it not? You joined in September, they
Yes.
took it back in January.
Yes. A year had not gone by. And just to recapitulate, my lord, in this order itself, it only states two things. The first one is that this is outside the financial provisions in the annual budget. And secondly, it is beyond the LADC General Service Rules 2011. Only those two aspects. But even if we are to say it violates what is interesting to note, my lord, is that it only merely vaguely stays beyond the LADC General Service Rules 2011. It does not specify any rule. Now, my lord, I have also gone through that Mohinder Singh's judgment, yes.
Yes.
Even that Mohinder Singh's judgment said it very clear.
That what was not there in the
Yes,
order
in the order
will not
cannot be improved in the subsequent affidavits.
Have you gone through it? Yes, sir. Yes, Lordship. So now your arguments that day trying to improve the case, will they stand?
So, my lord, those rules, Rule 27, Rule 7 of the LADC rules,
LADC General Service Rules, huh?
2011, yes.
Okay.
No specific rule has been stated that they say it is beyond this one. So now they cannot.
Does the General Service Rules permit creation of posts? Where
Yes.
was the rules you gave me? A copy,
Yes,
I
correct.
think. You had supplied a copy. These general rules are here. Are they attached here?
It has been supplied earlier to your lordship, my lord. I can also furnish my copy.
No. If we keep on taking all the copies, it will be difficult.
The reason why I'm saying that Mohinder Singh's case, my lord, now is because they cannot.
No, he handed me a copy. I went through it. Yes. I'll just have a look.
It's here, my lord.
And what is this? And that is what? What
This
are
is
you
the
going-
General Service Rules 2011.
Why is it so big here and so small there? Oh, General Clauses Act is here, okay. Can you just point out the creation of post it is allowed?
Rule 7, that is in page 3 in my copy, my lord, under the heading part 3, authorize permanent strength of the service. Now I'm saying these things at the outset, my lord. They cannot, what I would like to submit is that they cannot now, this is just for the sake of academic exercise. It is very, very evident in the order itself that they have not specified any rule. And the rule which we will go through now is only for the sake of academic exercise. They cannot, I don't think they cannot now retrospectively say, oh, we have used this Rule 7, Sub-Rule 2, and we have said these appointments, they are beyond the General Service Rules, Rule 7, Sub-Rule 2. They cannot now retrospectively say that. But simply and purely for the sake of academic exercise, what they are saying is beyond the LADC General Service Rules, then nonetheless it will be this specific provision. And this specific provision, it appears, it looks as if the appointments, they need prior approval of the governor. And that is what is implicit for them, my lord. What is implicit and what they appears to say, it is beyond the LADC General Service Rules. That the prior approval of the governor has not been taken, and that is why these appointments are illegal, void
The
ab
creation
initio.
of the post is illegal.
Yes. My lord, but however, I have earlier I have stated that this rule, it has to be read constructively and harmoniously with the Conduct of Business Rules 2010. I had taken your lordship earlier on Rule 27. The same is in, my lord, page number 49 of the writ petition. Your lordship has got it. Powers and functions of the Executive Committee. The Executive Committee shall dispose of all matters falling within its purview. Now this specific portion, my lord, is the enabling provision. I have read it again and again, my lord, and this is how I understand. The Executive Committee shall dispose of all matters falling within its purview. Now this is the enabling provision, and on the next sentence, except certain matters hereinafter specified. And this is the exception. And above and amongst the exception, in Sub-Rule 2G, therein lies appointment of all gazetted officers.
So you are saying that when it is a matter of a gazetted officer, it is only in those cases that the Executive Committee has to refer the matter to the District Council and then to the Governor for final
approval. Yes,
if
my
it
lord.
is for any other post, any
Yes,
other
my lord.
non-gazetted post, then this reference to the District Council or the approval of the Governor shall not come
Not
in.
required.
And you say it is when it is related to the appointment of gazetted officers.
Yes, my lord. And this one has to be read. This is the only way we can read it harmoniously with the 2011 rules. Sorry.
Okay,
And my lord, if I may also take you to the, if I may take you back to the 2011 rules, the Rule 7, even if I may read Rule 7, Sub-Rule 1, the authorized permanent strength of the service and number of the post therein at the commencement of these rules shall be as specified in the Schedule 1 appended to these rules. Now let's see what is there specified in the Schedule 1 of the rules. My Lord, Schedule 1 in my barrack is in page number 7. Your Lordship has got it? These are the service. These are the service which this particular rule said authorized permanent strength of the service and number of posts that should be specified. Now, when we see all these designations, it is very implicit that these are gazetted posts.
Huh?
So, my Lord,
Serial number 5, Roman 5,
my Lord, junior grade A.
these are gazetted posts.
I'm not sure, my Lord, but
Oh,
it
what do you
appears
mean
so.
by a gazetted post now?
Gazetted post, apparently.
There's a definition to the term gazetted posts.
um,
Those posts where the appointment
yes,
needs to come up in the gazette,
yes, correct.
and those posts which are already there in the gazette.
Correct.
These are called gazetted posts.
Correct.
Because anything, any service matter regarding the said persons are to come up in a gazette always.
Correct.
Those are gazetted posts. Gazetted posts are not, are non-gazetted posts are those where you don't need the interference of the gazette all the time.
Yes,
What
my
is a
lord.
gazette? The gazette is the official publication of the government.
My Lord.
And a post of an LDA may not be a gazetted post.
My Lord.
Senior posts, when you transfer senior person from one place to another, then there is a gazette publication. That so-and-so is now transferred to so-and-so. That is why they are called gazetted posts.
My Lord.
So, when those posts are under way, it's a different issue. Your first argument that appointment of all gazetted officers, these posts are not gazetted posts. Then what happens to the gazetted post? Non-gazetted post, where are they?
It is not here
In this?
in these general service rules, my
Yeah.
Lord.
What were the posts created for you?
Sanitation worker, Sardar, data entry operator. If I may take you back to,
So those posts will be included in this, has to come up in this schedule. They have to be included in this schedule.
no, my Lord. The reason why I'm reading out Schedule 1, I'm showing Schedule 1 is to show the legislative intent of how and in what manner Rule 7 has been framed by the legislators. Because I believe, Your Lordship, on the earlier occasion, Your Lordship believes that this wording, the authorized permanent strength, is synonymous with the creation of post.
No. Authorized permanent strength as on the date
Yes,
at the commencement of the rules. These are the posts. Thereafter, after the commencement, it will again be determined by the executive committee, because they have given, suppose they have given you the post of, let us say, district council, serial number Roman 4, serial number 4, or serial number Roman 6, taxation officer. Right. Page
Right.
number 7, see the taxation officer part,
my Lord.
or any other art and culture officer, suppose. Now they want to do away with that post, they don't need that post. In their functioning, they don't need a post. What will happen? After the commencement of the rules, they will say that, okay, now we don't need that post, they'll write to the governor will say, okay, you can do away with that post. Now suppose they want a post of an assistant art and culture officer. They will
Yeah.
again write to the governor, we want to have another post. Then the government will say, okay, they'll have a post.
My Lord.
That is how this court is understanding.
Yes, my Lord.
We are always
I
open
understand.
to a convincing on,
Yes, my Lord.
if you want to convince otherwise, we'll try to accommodate, but
Yes, my Lord. From my humble understanding, after reading this Rule 27 of the 2010 CCB rules again and again, the enabling provision, This power is so wide, and it shall dispose of all matters falling within its purview. This talks about many things: creation of posts, appointments.
Otherwise, it has got a very wide amplitude.
Yes.
All
And-
matters. Yes.
And, my lord, then comes the exception. And amongst the exception, appointment of all gazetted officers are there. Now, apparently, we are not gazetted officers, and it is, I believe, it is implicit from the orders of the respondents terminating our service that our appointment is in violation with the Rule 7, Sub-Rule 2 of the 2011 rules. But this Rule 7, Sub-Rule 2 of the 2011 rules, it has to be read harmoniously with Rule 27 of the 2010 rules, the enabling provision. It has to be read down, my lord, in such a manner, I believe, my humble understanding, it has to be read down, this Rule 7 of the 2011 rules, it has to be read down in such a manner that it pertains to gazetted posts only. That is my humble understanding.
Yes, anything else?
And now that, my lord, is, if we are to presume, now I have stated earlier that in the order, termination order itself, no rule has been specified. Now take that into consideration, the Mohinder Singh's case. They cannot now retrospectively say they are violating this rule. But it is only, I have stated earlier that that is the only for academic exercise. And now, my lord, if we are to state, on the other hand, if we are to state that our appointment only, just for the sake of argument, my lord, our appointment requires prior approval of the creation of the post, let's say. The creation of let's assume that the creation of the post requires prior approval of the governor from time to time because of the wordings used, the authorized permanent strength of the service is used. Then, if it also affects the strength, as in if it also pertains to the dissolution or the termination of the post, then it will also require the approval of the governor as well. And nowhere in the records show that the termination of this post as well as the dissolution of this post is...
For appointment, if the approval is required, for termination also the approval will be required.
Yes, that is what I'm trying to say, my lord. For the sake of argument.
There is a very dangerous sentence when you say for the sake of argument.
Yes.
It is just for the sake of argument, not for the sake of
Yes, just for the sake of argument.
Yes. So basically you are on 2 points. One, that the abolition, that the creation of the post did not require
Yes.
any rule, such rule to be followed, because it was entirely in the hands of the Executive Council to do so, and it was done so properly.
My lord.
The abolition of the post done on the grounds available in the order, those grounds are not sufficient because they are not specific as to on what basis.
Yes, it is
That-
very vague. Yes.
And they have not referred to any specific rule. That if the argument of the respondents that the appointments required prior approval is to be accepted, then equally it has to be accepted that if at the time of termination also the prior approval of the governor was required to be taken, which was not done.
Correct.
And thereafter, what was it?
And all those other matters stated in their affidavit in opposition, those things we cannot go there. The issues regarding the DPC and all those
That was never referred to in the order.
orders, yes.
That approval of the DPC and the other things.
Yes, yes. Your
Yes,
Lordship-
what do you say? That is also? Or anything else?
Yes, something more, much more is there, my lord.
Oh, much more is there.
Yes, yes, yes. My
Because-
lord, I have read certain rules framed up by the Supreme Court of India, wherein I completely understand that the policy of the government cannot be interfered so much by the court, and that I completely understand. But however, we have to also understand that this court is the court of equity and justice. Now, while on the other hand, we are saying that this court cannot interfere in government policy decisions because of the change in government, we also have to understand that will it be proper when every time a government is changed, laymen will suffer.
Not all laymen. Those laymen who take advantage of a particular government may suffer.
Correct. That is also correct, but can we oversee that aspect? Take
Okay.
into consideration the court, that this court is the court of equity. I completely understand, my lord, that this court have very, very limited powers to interfere in the government policy changing decisions. I completely understand. But we also have to consider during what is the policy decision taken during our appointments as well, during the creation of our post as well. It was not created out of haste. I've shown the affidavit in opposition of the exhibits of the affidavit in opposition. The records very, very clearly show that the policy makers during our time, during the appointment of our post, have made a very, very conscious decision. They even consulted the finance department. They even state, although there is this annual budget is not there, therein, we will try to make it up in the next annual budget. All these conscious decisions were taken. A deliberate and careful decision was taken, my lord. Now that cannot be deduced by only reading the order of the termination of our service and abolition of our post.
Any provision in this service rules regarding termination of service? I fail to find any.
Regarding probationers, my learned friend have read out on the earlier occasion, my lord. But not so specific
No, suppose a person
in
is
the
confirmed.
2011 rules.
Suppose a person is confirmed and then he has to be terminated for whatever reasons. It can be a disciplinary proceeding, or it can be because of a conviction, or it can be because of his ill health or whatever. Under what provision of law you can terminate, or there is no provision of law you to terminate?
Yes, Lordship.
My lord, if I may just submit that, although your lordship is well aware of this judgment, this Mohinder Singh Gill judgment, if I may just submit.
Anything else?
The relevant portion, my lord, is in
Oh, that we will find out.
yes, is in page number, in para number 8. Yes. And in the VP Ahuja's case that I have just submitted recently, in para number 7, it states,
Ultimately, your case will boil down to whether you were entitled to a notice before.
yes, my lord.
That is the only case.
Yes, my lord.
Because all this interpretation of the rules, whether this was correct, that was correct, whether they can take it back, they cannot take it back, before you argue it before this court,
My lord.
is it not that they should consider your arguments? You could have made all these arguments before that.
Yes, my lord.
In case you had given a notice, Now you
My
are
lord.
not given a notice.
Yes, correct.
So in case you are given a notice and you are made to understand that this is why we want to terminate you,
Correct. We
you
should.
will have your own arguments to place before them.
Yes, my lord.
Is it not?
See, even in
If
my
there is
lord,
any
yes.
procedural flaw in that, it is then this court can interfere. And
Correct.
that exactly is what perhaps your other judgment, this VP
VP
Ahuja has also
Ahuja,
said.
yes. VP Ahuja says.
You may be a probationer, you may be anybody.
Yes,
But before they say that, okay, go home,
yes.
there must be a basis, a foundation, a something.
Correct. A
And
bare
you
minimum.
must be aware of it.
Yes, my lord.
Suppose it's a probationer who's not working properly. Even in that case, I think they'll have to tell you, please work properly. We are finding you difficult. If you don't work properly, they can say that, okay, fine, probation ends. You
Correct.
go home. But there must be a warning to you.
Yes.
When they take away the posts, when they say that you were not appointed correct, what they have done in their affidavit. They've taken that stand that there was no advertisement, this proscription was not necessary, all that. That has to be told to you.
Yes.
Once you reply to it, they'll come to a particular finding and
Correct.
then after
We should
the
be given
finding-
the opportunity, yes.
But otherwise, all these things, whether the abolition was correct, whether their policy decision is correct, how can we comment on that?
My
Beyond
lord.
us, beyond our powers.
My lord.
Is it not? So to cut a long matter short, it is one without notice.
Correct.
Is it? Yes.
And,
What is-
and my lord, if I may kindly, if required, if I may be allowed to rebut the submission of the learned of my learned
yes,
friend.
yes, we'll
Yes.
see. What does he say? Let us see. Yes.
Yes, Lordship. First of all, I would like to begin by stating that the Lai Autonomous District Council is given power under the 6th schedule. And Lordship, sub-para number 7 of paragraph 2b of the 6th schedule para number 7, sub-para number 7 of paragraph 2b. Lordship, the LADC, it gave the power to make laws generally.
Para rule, sorry, para 2, sub-para
7.
the district or regional council. That is what you're reading.
Yes, Lordship.
The district or the regional council may, after its first constitution, make rules with the approval of the governor.
Yes,
With regard to the
Lordship.
matter specified in
Specifically,
para
B,
6.
para 2b, it can make laws, if I may read with your permission, it can make laws generally all matters relating to the transaction of business pertaining to the administration of the district or region, as the case may be. I would stop at that point, Lordship. And ultimately, the LADC Constitution, Conduct of Business, etc. Rules 2010, in short, CCB rules, was created in the year 2010. In that rule, Lordship, if I may take you to page number 29. Of the petition, Lordship, of the writ petition of the petitioners.
Page number
Page number 49.
49, yes.
If I may read out. Para number 25, staff of the Executive Secretariat. Point number 1, subject to Rule 19 of these rules, the Executive Committee may, from time to time, determine the number of officers and staff in the Executive Secretariat within its budgetary allocation, and appoint such officers and staff by observing codal formalities. Lordship, I would like to take you to page number 45 of the writ petition. Lordship, with your permission, Secretariat of the District Council. Under that, I would come directly to proviso, provided that while fixing the strength of the Secretariat of the District Council, if any extra or additional financial implication is found unavoidable, clearly, as my learned friend has pointed out, it was during the COVID-19 outbreak, and financial implication is there. As the finance department had said that more than 400 lakhs would be short. However, Lordship, if I read this point, if any extra or additional financial implication is found unavoidable, then no such decision shall be taken without prior approval of the governor. Lordship, in this matter, no prior approval of the governor is taken prior to the creation of posts, although there is obviously a financial implication. Lordship, also another point regarding whether post creation is within the financial provision of the annual budget 2020 to 21. Lordship, for a post to become effective in the LADC, it should be provided in the budget of the LADC, clearly indicating the pay heads from which they should get their salary.
No, sir, what is happening is this. You are arguing against yourself. It is your own council which is creating the post. It is your own council which is appointing people, and it is your own council who is saying that no. This is how the council should do it. Therefore,
Yes,
appropriate,
Lordship.
reprobate. How can you? You are saying yes, the council has done it. No, the council cannot do it.
Yes.
Are you trying to pull or push? Is it hot air or cold air?
Lordship, however, the wrongdoings of the predecessor cannot be borne by the existing.
No. This council is in perpetuity. Members are predecessors, or it is the members.
Yes, Lordship, I understand.
You are defending the council, not the members. You have to defend it as the council, not as the member. Not as the new executive member. You have to defend it like you are defending the executive council itself.
Yes, Lordship, I understand that.
Because what you are saying is we are finding a bit difficult to take only because the same council is taking two stands. One, while appointing them, now while dismissing them.
Yes, Lordship, I would come to that in a bit. Yes, I know that it is committed by the LADC itself, but later on, it was found out that
now you are on the right track. Now
During-
you are on the right track. Yes.
during the probation of the petitioner's hearing, it was found that by the executive committee, it was found that no proper steps in order to appoint the petitioners were taken. Like, no budget was there, and there was no documents to show that they in fact got necessary qualifications for those posts. As
Any
they were,
advertisement? Any
yes,
advertisement made?
yes,
Was there an advertisement before the appointments? Any selection process, anything?
I will have to take instruction regarding that, my lord.
Yes.
so during probation, as there is a specific provision of law, a specific provision in the Lai Autonomous District Council General Services Rules 2011 that a probationer can be terminated. They terminated due to the fact that certain irregularities occurred
That is where
for the
that is
appointment
where
of the
problem
petitioners.
starts. That is where the problem starts. You found something irregularity or illegal against them, that this was not followed, that was not followed, that was, so your appointment is banned. That is your case?
Yes, Lordship.
Now, if
Ultimately.
that is the case, when you find out a fault in the process, or you find out a misconduct, or you find out an allegation that it was not done properly, is the requirement a notice to them? Can it be done in the manner it has been done? Initially, I have pointed out that I will not go into the merits of the decision taken. If you have material with you, you may take a decision. Unless it is perverse, we will not look into the merit of the decision as such.
Yes, Lordship.
But what we will look into is whether he had the opportunity to defend himself. Even a probationer, it cannot be a case that you are attending office every day and one fine morning you are told, please go home. Cannot be. It has to be, look, you are not working up to the mark. Please work up to the mark. Still that man does not reach up to the mark. Then on the second day you can say, please go home. I don't need you further. So that may not be in the form of a proper notice. But then that man had a notice that this is wrong. I am not working properly. They have a feeling that I am not working properly. I should work some bit more. Is it not? So he had some kind of a notice. In their case, it is not that you are not finding them fit to work. You are finding a fault in their appointment process. Is
Yes,
it not?
Lordship.
So now that is your point of view.
Yes,
They
Lordship.
are going to lose a livelihood. Are you not required to give them that notice and the opportunity to say that no sir, you are wrong, let us understand the law like this. Perhaps they can convince you to understand the law otherwise. Maybe you will not be convinced, but they will have their attempt to say so. So the notice was required. That notice is absent. It is totally absent.
Yes, Lordship.
Even if it is an illegal appointment, yet he has to be told, sir, illegal appointment, unless and until it is a forged appointment. If the paper is forged, signatures are denied. In that case, you come through the back door, you go out through the back door. There is no issue, no problem with that. But here is a case where you admit that the Executive Council has appointed them.
Yes, Lordship.
There was a flaw in the appointment. Now they may have a case to tell you that, sir, that is an irregularity, please regularize it and we can continue to work. Or they can say, okay, fine, this is an illegality, we can't help it, sorry, we have to go home. They'll do something. But you have to tell them before you take the action. Without notice, termination. So instead of all the powers that we are trying to discuss here, the arguments that he has made regarding the powers of the council to do something or not to do something, this is something which he has to place before the council. And this is where you are wrong. You are saying that you need the approval of the government. Our argument is that you don't need the approval of the governor. They may argue that. You may reject it. But first you have to look into it. To look into it, notice, no notice. Big problem.
Yes, Lordship.
So, all others, all the things that you are showing here are will come later on. Once we hold that the procedure in terminating was correct, then we will see whether the merit in the termination is correct or not. But here we are finding the process wrong. And this court sitting in Article 226, we would not like to write down in our judgment that this is also we are evaluating and meriting, so that then you will not be left with the decision. We will be taking the power away from you because you will decide whether your argument is correct or not. Instead of that, we will stick to the only procedural part, instead of going into the merits saying you are wrong or he is wrong, or rather let's say he is right or you are right. What we propose to do is, absence of the notice, this termination goes. You will have the option of giving them a notice within the next 3 weeks. They would have an option to reply, have everything on record before you in the next 3 weeks. Right?
Yes, Lordship.
You would give them a personal hearing,
Lordship.
come to a final decision. Till such time, their termination stays in abeyance. They remain your employees. The moment you take the final decision after doing the process, then you can come to a decision, take action. That is what this court is finding the result. Unless you can show us that there is a notice, we'll have a time frame on that. You give them a notice, give them the time frame to answer. They
Yes,
will
Lordship.
give their answer, hear them, take a decision.
Lordship.
And till such time, the termination order has to be in abeyance. They would be entitled to their rights under their appointment. How quickly you can do it is up to you, if you want to terminate them. And if you find out from their arguments that they can be retained, it is up to you to retain them.
Yes, Lordship.
So we'll dispose this off. Yes?
Yes, Your Lordship. To add a layer to your Lordship, just to add some layer. If we were given a notice, we could have raised all these points.
That is what I'm saying.
Yes.
The absence of a notice is what is disturbing the
Yes.
The creation of the post, whether it was legal or illegal, if we decided today, there will be no point in giving them a notice. We don't want to comment on that. Either ways, we don't want to comment.
Oh my God.
But we would say that this order that you have come, page number 240, what? 249. 249. है ना? This is an order without notice, taking away service.
Correct.
The allegation is not one of forgery or fraud.
Yes, Lordship.
It is of illegality or irregularity. In which case, they will have the they will have the right to notice.
Yes, Lordship.
You can take up all your grounds: no advertisement, no qualification, overaged. Whatever grounds are permissible in law and whatever grounds you find in the records, take every ground against it. Let them reply to it.
Lordship, however, if a new notification is furnished to them, the period of probation has already elapsed.
No, if the termination during the probation period was wrong, then they'll be deemed in service, na? And if the termination, if you find that yes, it was a good ground for termination, then they get nothing. There is a solution to every problem
Oh my God.
if we try to solve the problem.
Yes,
If you
Lordship.
want the problem to remain, it will remain for quite some time. We can keep it for quite some time. I think it can be, you give them the notice. Well, when did your probation end? see, they came to the court within the probation period. Na?
Yes, Lordship.
The probation is for a period of 2 years from 2020.
2020,
2020,
21, the date?
from the month of October.
October 2020, so October 2022, their probation would have ended. You terminated it prior to that within 4 or 5 months.
Yes, Lordship.
So now, in case you find that they are required to continue in service or the posts can be retained, in that situation, they would join back in their posts and you'd continue their probation. Taking that 4 months probation was done and now we are giving another 16 months of probation. 20 months of probation you have to continue. In case you find that the posts cannot be retained and their appointment was illegal, 0. They will not be entitled to anything after the date of their termination of 20th of January 2021 unless you come to a decision. If
Yes,
you
Lord,
hold
sir.
that the termination is wrong, then you would have to pay them for a wrong termination. And in case you find the termination is correct, your earlier order stands. They don't get any benefit. Because we can't allow them to join back now. When the question is one of illegality and yes, shall we dispose it off quickly?
My lord.
Yes, Lordship.
Yes. Take down heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. So-and-so learned counsel appearing for the respondents, full stop. This matter was heard at length on, where is that order? (14/11/2025) and was directed to be listed today as a part heard matter, full stop. Both the councils, both councils appearing for the contesting parties have made their submissions and this court has also produced the materials available on record. Full stop. Next paragraph. This writ petition has been filed by the petitioners, aggrieved by the order dated 28/1/2021 issued by the respondent authorities, by which the posts on which the petitioners claim to have been appointed were abolished and the services of the petitioners were terminated consequentially. Full stop. The writ petition was filed in the month of December 2021, although the termination orders came in the month of January 2021. Full stop. Next paragraph. The case of the
No, my lord,
petition.
the writ petition was filed in the year 2022.
20?
2022. This instant writ petition was filed on 2022.
Okay, you take that paragraph. This the writ petition was prepared for filing by swearing the prepared for filing in December 2021 and was filed on the 12th of January 2022. Full stop. The case of the petitioners, as reflected in the records, is that What was this first writ petition? What is this judgment about?
The judgment
Page 205?
that is regarding the appointments of what
Eh? Sorry?
appointments of other services, my lord. In the
Then page 222, what is it?
this 222 relies on this WPC 64 of 2018. This writ petitions, we are annexing this because they states that the district and the executive committee have certain powers for appointments. And your lordship has also read it earlier. It pertains to appointments of gazetted post. Your lordship has read page number 225. These issues are regarding approval of the governor in appointing gazetted post.
In that case, the persons were appointed to the already existing posts,
Yes,
and their services were sought to be terminated because the approval of the governor was not taken. Is
yes,
that how?
that is their case.
And then
But
the
the
court
judgment-
came to a finding
Yes,
that for non-gazetted posts or for those posts which already exist, the approval of the governor is not necessary. You can do an appointment, and therefore
correct,
there is no mistake. But here
Correct.
the question is one of creation of posts.
correct.
That was not decided in these cases, was it?
Yes, yes, my lord.
Creation of posts is not decided here in these earlier cases.
Yes, it deals with appointments, my lord.
Only appointment part.
Yes,
But here we are also concerned with the creation part. So I
My
don't
lord.
think these judgments are they relevant.
we are annexing these judgments just to show to this court that the LIDC executive committee has the power.
To appoint.
Yes, to appoint.
To appoint.
Yes, to appoint and
Okay.
while filing to create. That is our presumption. Yes.
Okay, you take up that ground in your representation.
Yes,
before.
yes, my lord.
We will decide it goes here and there. Yes.
My lord.
What did we say? The facts. What did we say? The writ petition. What did we say? Is that by an order dated by notification dated 17th of September 2020, the Lai Autonomous District Council had created 2 posts of sectional assistant, 4 posts of Sardar, 1 post of data entry operator, and 1 Group D post. Full stop. By another notification of the same date, 2 posts of trained. What is this trained? Only
Trainer. Trainer.
trainer.
Yes.
2 posts of trainer, 1 post of data entry operator, and 6 posts of field worker were also created. Full stop. It is the further case of the petitioner that on the 1st of October 2020 and that on the 1st of October 2020, 18th of September 2020, 8th of October 2020, 7th of October 2020, Any more dates? The petitioners came to be appointed in the aforesaid posts in their own capacity, in the aforesaid posts, comma, which appointment was subject to approval of the DPC, full stop. The appointments were made in the interest of public service with the condition that the incumbent appointed would be on probation for a period of 2 years with effect from joining duty. Full stop. By an order dated 28th of January 2021, comma, the petitioners were informed that the Executive Council of the LADC had taken a resolution that the creation of the posts to which they had been appointed were outside the financial provisions of the annual budget of 2020-2021 and beyond the Lai Autonomous District Council within general service rules, comma, 2021, and as such the creations were termed to be void ab initio, full stop. The said order further communicated that the Executive Committee in its meeting held on 13th of January 2021 had resolved to nullify and revoke the aforesaid orders and all appointments made thereof on the strength of these said orders, full stop. It was informed by the order that in consequence of such nullification and revocation of the creation of the posts, comma, the services of the appointees in respect of the above revoked posts stood terminated with immediate effect, full stop. Next paragraph. This writ petition has been filed challenging the aforesaid order, full stop. Mr. So-and-so learned counsel appearing for the petitioner has referred to the different provisions of the Lai Autonomous District Council within bracket General Service Rules, comma, 2011 and the Lai Autonomous District Council within bracket Constitution, Conduct of Business, etc. Rules 2010 to impress upon this court that the decision taken by the council regarding violation of provisions of the rules of 2011 are not correct, and therefore the revocation of the creation of posts is illegal, full stop. He has further submitted by referring to the affidavit in opposition filed by the respondents that the grounds taken in the affidavit in opposition are not the grounds reflected in the impugned order dated 20th of January 2021, which amply demonstrates, comma, according to him, comma, that the order is not sustainable in the form in which it was passed, full stop. The learned counsel for the petitioner has further submitted that it cannot be the case of the respondent authorities that even assuming that the powers, that they had exercised powers for termination of services of probationers, comma, the same could have been done without any notice to the present petitioners, full stop. He has submitted that the creation of the post and the manner in which appointments had been made were not at the hands of the petitioners, and they had merely accepted the appointments which was made by the respondents, and they had and acting in furtherance thereof, comma, they had joined their services and were faithfully rendering their services, full stop. In such view of the matter, comma, the Learned Counsel prays that the impugned order dated 20th of January 2021 be interfered with by this court, and the same be set aside and quashed, comma, entitling the petitioners to all consequential benefits thereafter, full stop. Mr. So-and-so Learned Counsel, appearing for the council, has submitted that what was the provision? Yes, that the provisions of the conduct of business rules provide for a specific manner in which a post can be created within the Secretariat of the Executive of the Council, within the Secretariat of the Council. And that such procedure had not been followed when the posts were created, full stop. He has also raised an allegation that the appointment of the petitioners suffer from illegalities, and therefore it was incumbent upon the council to take a decision on the legality of the creation of the posts, and also with regard to the continuation of the petitioners in their services, full stop. The Learned Counsel for the respondent has submitted that in any view of the matter, the period of probation of the petitioner has now ended, and there can be no question of reinstating them in service at this point of time, full stop. The Learned Counsel for the respondent has also submitted that the prayers made by the writ petitioner are misconceived to the extent that abolition of posts is a matter of policy decision, comma, which this court would be loath, L-O-A-T-H-E, loath to interfere with unless procedural lapses are pointed out. The Learned Counsel for the petitioners have referred to the judgments of the Apex Court delivered in the case of Mohinder Singh Gill and another versus Chief Election Commissioner, comma, reported in 1978, 1 SCC 405, and the case of V.P. Ahuja versus State of Punjab and others, comma, reported in 2003 SCC 239 to buttress his arguments. Full stop. Next para. This court has gone through the pleadings, comma, the provisions of the LADC within bracket General Service Rules 2011, the General Clauses Act, and the LADC within bracket Constitution, Conduct of Business, etc. Rules 2010, and also, no, which were referred to by the Learned Counsel for the petitioner, and also the provisions of the 6th schedule to the Constitution of India as referred to by the Learned Counsel for the respondents.
Lordship,
Yes.
the General Clauses Act is submitted by me.
By you,
Yes, Lordship.
this one?
Yes.
Okay. Then from the petitioner you cut out the general clauses and you add it to the respondents. You also produce it, no? You are not
General
depending on the
clauses,
general
no, my
clauses.
lord.
Okay. The general clauses you bring along with the respondent, huh? Okay. Yes, any other submissions I should record now?
We are submitting that these two provisions should be construed harmoniously, those things.
You want a decision on that the moment I start
No, no,
recording
no,
all
no,
that
no.
I'll have to start deciding all that.
No, my lord.
Ah.
No.
Okay. Although elaborate arguments had been made by the Learned Counsel for the petitioner regarding the manner in which the different provisions of the rules have to be interpreted and interpreted, comma, this court finds that there is a procedural lapse on the part of the respondent authorities in terminating the services of the petitioners without having given them any notice of such action proposed to be taken against them. Full stop. It is a settled position in law that unless an appointment is taken to be a fraudulent or a forged or based on forgery, comma, incumbents serving on a particular posts are entitled to a notice of the intent of the appointing authority to terminate their services, comma, prior to effectuating such termination. In the present case, it is noticed that while the petitioners came to be appointed in the month of September and October 2020, comma, within 4 months of such appointment, comma, the respondents have taken a decision to abolish the posts and also to terminate the services of the petitioner. Full stop. In the considered view of this court, such termination cannot be resorted to without a prior notice to the petitioners, comma, bringing to their notice the reasons for such intended termination, and if required, to give them enough and adequate opportunity to contest the claim of the respondents regarding the creation and the intent to abolish the posts on which the petitioners were serving. Full stop. It would only be thereafter incumbent upon the respondents to take into consideration the grounds raised by the incumbents serving in the post and come to a conclusion regarding the abolishing of the posts and the termination of the petitioners, full stop. In the above view of the matter, comma, this court has no hesitation to hold that the order dated 28th of January 2021 was passed without any notice upon the petitioners regarding the intent of the respondents to terminate their services, full stop. The order dated 20th of January 2021, insofar as it relates to the termination of the services of the petitioner, is accordingly interfered with. Full stop. Since the ground taken by the respondent authorities is the requirement of abolishing the posts held by the petitioner on the ground that it was outside the final provisions of the annual budget and also beyond the Lai Autonomous District Council General Service Rules 2011 itself, comma. This court directs the respondents to serve notice upon the petitioners regarding their intent to abolish the posts on the grounds mentioned in the order dated 28th of January 2021 and also their intent to terminate the services of the petitioner on petitioner, comma, specifying all the grounds that the respondents would rely upon to deem the deem it necessary to terminate the services of the petitioners, full stop. Such notice shall be served upon the petitioners within a period of 3 weeks from the date of receipt of a certified copy of this order. 3 weeks will do? You need more
Lordship,
time?
if permissible, 1 month may be given.
Okay, 4 weeks from the date of receipt of a certified copy of this order, and the petitioners herein shall be afforded sufficient and adequate time, comma, not less than 3 weeks to place their replies to the aforesaid intention of the respondent authorities. The respondent authorities would also give a opportunity of personal hearing to the petitioners, since an allegation has been leveled in the affidavit in opposition regarding the legality of the process of their appointment also, full stop. The respondents would then be at liberty to take a decision on the requirement of either abolishing or retaining the posts being held by the petitioner, and also on the legality of the process of appointment of the petitioners, full stop. Such decision shall be taken within an outer period of 4 weeks from the date of affording personal hearing to the petitioners, full stop. Till such time, the order dated 28/1/2022. Sorry, cut that out, because I've already interfered with it. Why should I keep it in evidence? It's interfered with, no? Okay. The regularization or otherwise of the services of the petitioner from the date of their termination to the date of the decision being taken by the respondents shall be dependent upon the outcome of the decision being taken by the respondents on the representation of the petitioners. Full stop. The petition accordingly disposed of. Oh, prior to that, you write, it is made clear that this court has not decided or observed upon the validity, upon the merits of the arguments and submissions made in the writ petition, and it is left open to be decided at an appropriate stage.
I'm deeply grateful, my lord.
Right? You take up all the grounds you want to. You have not
My
decided
lord.
anything.
Obliged, Lordship.
Deeply obliged.
Okay. Writ petition disposed of. Attorney, any more matters? Yes. We'll just ask them. Item number 18. Where is that list, cause list?